Today we're talking about depositions. We're going to start with some basic rules. In federal court, each side is given 10 depositions that don't require permission from the court. That means the first 10 depositions they just conduct. Beyond that, it is possible to depose more people, but you must ask the court's permission and have a good reason for asking in order to get it granted. Now, in this case, there are so many lawsuits within a lawsuit and so many defendants, so I don't know if they were granted more or how that all worked out. You also have limits to length of time. Generally, you have 1 day per deposition, and that day is limited to 7 hours. Again, case by case, you can ask for longer, but that's completely up to the court, and you must show cause for why you need longer than the allotted time. Some of you ask what happens if Blake cancels her deposition on Monday. She can't just not show up. First of all, her attorneys would never stand for that, but she could ask to be excused for illness or emergency. There are times when they can say they don't have enough materials needed and get it postponed, but we're a little late in the game for that now since the deposition is tomorrow. If that was going to be a reason, that should have been decided last week. But if she's going to try and say there's illness or something unexpected, the court would most likely forgive and allow her to reschedule. Another question was, is there a limit to how many times she could cancel? There is no set limit, but if the court suspects that you're intentionally avoiding a deposition, there could be sanctions. Sanctions have a wide range. They can be monetary, such as a fine, or being forced to pay opposing side's attorney's fees for something that you caused. They could be an exclusion of evidence or an exclusion of a witness. So, for example, if somebody continues to avoid their deposition, the court could sanction and say, this witness is eliminated. In extreme cases, there could be contempt of court found, which would include large fines or possibly jail time, but that's pretty rare. Depositions are recorded by audio and by stenographer or court reporter. They can be video recorded with prior notice, and these recordings can be used either read back if it's a transcript or played during a trial if it's audio or video. The one that's being deposed is sworn in the same way that a witness is sworn in before giving testimony in a trial. This is very important, and that's why it comes with the risk of things like sanctions, impeachment, and perjury, because it's taken under oath. Now, what if an honest mistake is made because maybe you were nervous, you maybe misspoke, or you remembered something incorrectly? There are methods of curing that, and we'll get into those in a moment. Depositions will probably not see the light of day in most cases, except for in cases that go to appeal. You will sometimes find the transcripts of depositions within appellate material. Besides of being used with the rest of discovery to help make a case, they can be used in court in very specific circumstances, such as a witness not being available, or what I've seen most often is for impeachment purposes. So say a witness is happily testifying in court and the story they give in court is exactly as it's always been told, it matches the evidence, it matches previous testimony, the depositions will not be brought up. But if the witness is not saying the same thing they've said before, if they're claiming they don't remember, or if they're giving contrary testimony, now the attorneys have cause to pull up the deposition. As I said, they can pull it up in transcript form and read it off, or they can play the audio or video to remind the witness of what they said either as a refresher, because sometimes a witness is just nervous. Sometimes it's because it's been years getting to a trial, and things that happened years ago are kind of hard to remember. So it's not always a matter of a witness being intentionally troublesome. Sometimes it's an honest mistake. Sometimes, though, a witness is being belligerent or obviously completely changing their story. That's when these recordings can be used as impeachment to show the court and the jury that the witness is being dishonest. More on that later. What kind of questions can be asked at depositions? The line of questioning must be relevant, but it's not really limited like it is at trial. you'll see pretty soon that after the discovery process, when they get to preparing in earnest for the trial, each side is going to try to make certain bits of evidence or certain facts off limits for the trial. I suspect in this case, there's going to be lots of fights over that. And we'll get to all that when the time comes. But I say it now because at this time, during depositions, they don't have much that's considered off limits. Of course, things like privilege do stand firmly in place. So asking about irrelevant health issues, for example, would still be barred. Things that the court has been ruling on lately saying that they're privileged, those will still be barred. But basically, anything relevant to the case that's not privileged can be asked. And the beauty of it is that unlike court, where opposing counsel can object to nearly every question on multiple grounds, things like relevance, hearsay, leading, argumentative, etc., these are limited during depositions. Besides of privilege or anything that the court may have deemed off limits, attorneys may only object to the form of questions. They do so simply by saying, object to the form. It means that they don't like the way a question is asked. It can be because they think it's unclear. It can be unclear technically, grammatically, logically, and they think that it needs to be asked another way. They could just be upset about the question, or they're trying to throw the other side off. But in depositions, they can be forced to stop and threatened with sanctions if they are abusing their right to object. They're not supposed to get in the way of the deposition by overly objecting to the form. The funny thing is, the attorney asking the questions really doesn't have to do anything about this kind of objection. They can choose to reword the question, or they can just ask the same question again in the same way, and the one being deposed must do their best to answer. The objecting attorney simply notes their objections as something possibly to use later. Some of you have asked, what happens if she just keeps replying that she can't recall? Well, she wouldn't be the first one who tried to evade the questions by pretending not to remember. So, of course, there are remedies. The deposer may share a document or piece of evidence and ask whether it helps trigger her memory. They can ask if she doesn't remember an event at all, or if there's just some of the details she's fuzzy on. They can follow up with many questions to sort out if it's really a memory issue or an avoidance issue. They can ask if she ever knew it and forgot it, or if there's something that would help refresh her memory. But it's important not to argue. The best thing to do, if you think that someone is being avoidant, is just to make a nice record of everything to impeach them with. You can find other times they've made statements to show the court that they were simply not cooperating. For example, you have all the causes of action in a complaint. Along with those causes of action, there's a brief telling of events. You also have their answers to interrogatories. Between just these two basic documents, there should be a pretty direct telling of events. You can use these documents to help refresh their memory. If that doesn't work, it could start to show their lack of credibility, because how did they answer the interrogatories? How did they file a complaint if they don't remember these things? But as I said, attorneys make a record, they preserve it as a means to show a pattern of inconsistency, which can be used for impeachment, or even to file for sanctions, or to compel them to sit for another deposition. There are times you can even contact the judge during a deposition, this is depending upon the judge of course, and have a quick Zoom conference. The bottom line is, it wouldn't be the first time, and the court is not going to let someone slip by unscathed for purposefully blowing a deposition. Another question people had is whether or not she can refuse to answer a question. Now, I'm assuming you guys mean something like pleading the fifth. It's important to note that the rules are quite different in criminal court versus civil court. However, there could be a real danger in incriminating yourself in a civil case that could lead to criminal charges. Now, this makes me think of Stephanie Jones and her wiretapping charges, for example. If she were to be deposed for this case, she may want to plead the fifth instead of admitting that she committed 3 federal crimes and 1 state crime that were mentioned in the civil suit that added her as a third party? It could even be Blake for having this information that was retrieved in a questionable way, perhaps criminal way. But let's talk about the rules for that. You would have to repeat the plea for every question that you refuse to answer. Now, a big difference between criminal and civil court with the fifth is that in criminal court, the jury cannot assume that you're pleading the fifth because you're guilty. But in civil court, you absolutely can. The jury can draw that inference themselves. They can be directed to draw the conclusion that refusal means guilt. So it's not a wise decision to choose to plead the fifth in a civil case. I think you would have to weigh the risk of being charged criminally with being found guilty in civil court. At least in civil court, you're not going to go to prison. Choosing the fifth is also something that the court can review after it's declared, and they can make a determination on whether or not it was properly invoked. Another question is, what if you realize after the fact that you said something wrong in your deposition? Is it set in stone? No and yes. No, you can use something called an errata sheet. These are forms you fill in where you find the part of the deposition where you misspoke, you write out what you said incorrectly, and then you fill in what you meant to say or should have said. From the time of your deposition, you have 30 days to do this. There are, of course, a lot of issues with these, as expected. And just like every aspect of a lawsuit, from the filing of the complaint to the jury charges, of course, there are rules to govern it. This particular rule is Civil Rule 30. These rules have been fought many a time in an effort to decide how limiting an errata sheet should be. But the rules themselves are pretty loose about changing even the substance of an answer. People have gotten carried away, causing these things to be appealed. I love the response one judge made in such a case, saying that a deposition is not a take-home project because a particular witness got their deposition transcript and basically sat down and rewrote it. You may find it shocking to see that a yes can be changed to a no, a previous action that was denied can now be admitted, saying you saw someone come home at 8 can be changed to you saw them come home at 10. A lot of these things can be changed. Now, when you hear this, it might make you nervous because if we know anything about Blake, we would expect her to be the one to take authorship of those sheets, take them home for 30 days, and completely rewrite them or have Ryan rewrite them like they did the balcony scene. But there are some guardrails to that. Remember I said yes and no. Here's the yes about it being set in stone. Even though the sheets can rewrite a lot of the content, the original will stay intact and it will remain available throughout the lawsuit. So, if someone is taking too many liberties with changing their story, attorneys have the original that they can use for impeachment to show how much a deposition testimony has been changed. Imagine you're sitting in a jury and you see that and how you're going to take it. That witness will suddenly lack credibility. And of course, there's a rule on how to handle that. This is Rule 613, and it puts limits. You can't just hear a witness testify in court, state something inconsistent with what they said back at their deposition, pull out the deposition with a big aha. You would have to ask them about their previous statement that they made during their deposition, give them a chance to explain. If their counsel requests a copy of the material you plan to use to impeach them, you must provide them with it, because unlike TV court, real court doesn't like those dramatic gotcha moments that come as a surprise. And Rule 613 is one of the rules in place to stop that from happening. But if those methods fail and it doesn't get sorted, then of course you can show it in the courtroom as proof that they're not being honest. And that's impeachment. My Murdaugh crew saw that happen. Of course, it was a criminal case, but it's impeachment all the same. When Alex started to describe the reasons that he lied, Creighton Waters gave him so many chances, conferred with his counsel, and then pulled out the videos of the police questioning him the night of the murders and within the next couple of days of the murders. And that was Alex Murdaugh being impeached. Another question a lot of you asked is why they would do a deposition now when they don't have all of the discovery. Several of you asked, couldn't there be something important that's missed if they do the deposition before they have it all? That's an excellent question. And the answer is yes, something important could be missed, but timing is everything. So you learned about the errata sheets. They have 30 days to fill those out. If you keep in mind that depositions must be completed by August 14th, you don't really want to wait until the last minute. We're going to talk about why. You want to have plenty of time to allow time not just for the deposition, but for those sheets to be filled in and to deal with anything that comes from those sheets. That's just one reason. An important thing to keep in mind is that if something big or important is discovered after the deposition, you can absolutely ask the court to depose again based on the new information. So, it's much better to have the bulk of the depositions done now with a chance to clean up anything that's missed later than to have to rush or miss something because you passed your deadline. A very important point is that you often learn new things in a deposition, things that you'll want to request new discovery for. If you wait too long to do the deposition, it may be too late to request discovery after. Maybe you don't learn it in the deposition, but when they're going over their sheets and then submit them 30 days later, there's something new in those that you might want to request discovery for. If you've put the deposition off to the last minute, it may be too late. Another reason not to wait is that fact discovery ends the same day as depositions. They have the same deadline, so you really don't want to put it off to the last minute. After August 14th, the only discovery that's left is expert discovery. Things like psychologists, in this case it could be producers, people that can explain the process of how the movie was supposed to go to prove that Blake did overstep. There could be people from SAG to speak about how you properly report SH claims. There could be intimacy coordinators to look at the footage to see if there's a problem. There will no doubt be phone experts to describe the phone retrieval process. A number of experts along those lines. Now that discovery won't finish until October 15th. But the fact discovery, that's all of this written stuff that they're collecting and these depositions, that deadline is August 14th. So basically, if you want to have time for those 30 days for them to fill in their sheets, to have time after that in case you need to request more discovery, these depositions need to take place within the next 3 weeks. Also remember the sheer amount of defendants we have in these cases. One deposition takes a whole day. It's not like you can knock out 2 or 3 in the same day. You're working with multiple people's schedules. Not everybody lives in the same place. Things have to be arranged. Attorneys might have to travel for these things. If they've not all been scheduled and we only have 3 weeks left, that could get really, really hairy. Additionally, there's something else we haven't talked about yet. It's something called requests to admit. These are documents that are due on the same day as the fact discovery and depositions are due. A lot of things, a lot of important things, have the same deadline. Now, these are very important tools. At the beginning, we had interrogatories, and these are kind of similar, but a little more serious. These are in preparation for the actual trial. You basically go through all the accusations that you plan to make, and you ask the defendants to admit these accusations. That's why it's called a request to admit. Each defendant will have to answer these questions. They answer by admitting or denying. And now if they deny, they have to give an explanation of their denial. This gets the agreed upon things out of the way, so the attorneys don't have to waste time preparing for them or bringing them up in the trial. You'll sometimes hear an attorney in court say to a witness, "You'll agree with me that," and then go on with the questioning. These can be from these requests to admit. It starts off on an agreed upon ground, and they proceed from there. Because they're so important, both what you receive from opposing counsel and what you send to opposing counsel, pretty important, you'll want information from your depositions to go on them. Again, another very important reason to get these depositions rolling now, so you can get that information to use on these documents. We're getting very close to July. These three big things looming, in addition to everything else they're doing right now, you better believe these attorneys are sweating it right now. The nice thing is, after these big deadlines on August 14th, things should go quiet for a bit, because after August 14th, like I said, it will be down to expert discovery, and that's not due till October 15th. Because these aren't parties to the case, there should be a little less squabbling. Although with this case, you never know. The attorneys will be busy preparing their cases, going through the mountains of discovery they've collected, so it shouldn't really be too noisy until it's time for motions for summary judgment. Those are due by November 5th, and I imagine those are going to be noisy and noxious. They're very similar to the motions to dismiss. The motions to dismiss happen early on, and the motions for summary judgment happen not long before trial takes place. It's kind of a last-ditch effort to say, hey, judge, they have not proven their case. They've got all this discovery. They haven't been able to make a case. Present it to the judge, and he can either grant or deny. The difference in this and a motion to dismiss is summary judgment is an actual ruling by the court. It has the same effect as if a jury ruled, down to the fact that it can be appealed. So we can expect that to be a very contentious time period. But speaking of motions to dismiss, I'm a little hopeful that on the 23rd, which is the deadline for the amended complaints, it's also a deadline for something that hasn't been mentioned. That something is called a motion to reconsider. Now, what is that? Although the judge granted the motion to dismiss with prejudice, you can file what's called a motion to reconsider, and it's basically asking a judge to change his mind. In this case, it would be to change his mind on those motions to dismiss. Now, you might say, but with prejudice, doesn't that mean you can't refile an amended complaint? And that's true, but this is not an amended complaint. This has very narrow, specific rules. You can't simply rehash the same arguments that the judge dismissed. It's not a rewriting of your complaint. It's limited to three things. It must be either a clear error of law or fact, new evidence that wasn't previously available, or an intervening change in controlling law. Now, there haven't been any changes in law. Judges hate to admit that they've made an error of law or fact, but there very well could be new evidence that wasn't available before. I'm extremely hopeful that we're going to find one of these filed on Monday with information about the sham lawsuit, the sham subpoena, this new information that Perez Hilton found. Now, I don't know if you guys saw this, but this is very exciting. He found an old NPR interview with none other than Megan Twohey of the New York Times. In this interview, she quotes Blake. Now, this is interesting for many reasons. One of them being, she used privilege by saying that her article and her video were based on judicial proceedings. Now, it was already a stretch because she also referred to thousands of pages in texts and emails, and you know that that sentence has been stuck in my head from way back. That is not part of a judicial proceeding, and I will die on the hill that the judge misruled by assuming, that's the word he said, assume, which chaps my hide, that those pages that he never laid eyes on were in harmony with the CRD complaint. It was bad enough that he allowed that. But now, with Megan admitting to actually speaking to Blake, that's another source besides that complaint. But the biggest thing is that Megan Twohey says that Blake told her,
and this was actually not the worst that I have experienced in Hollywood. I've actually experienced far worse misconduct. You know, I spoke up because I wanted to address it, and I thought that I had, and I never had any intentions of discussing this or going public with my accusations.
Interesting that she didn't pursue anything with anybody else, but she is with Justin, which leads to the question, why? Well, Blake answered that as well, and Megan repeated it to NPR. She said she had no intention of making this accusation until she believed there was a smear campaign. That's a big deal. And I'm so glad that Perez Hilton found this and put it out there, and I really hope that Brian Friedman heard about this so that he can ask Miss Lively about this. The audio's out there. Megan Twohey said it. This is very important for multiple reasons because it's a huge question. It could bring the defamation case back. Not only that, if this came from Megan Twohey of the New York Times, she might need to be deposed. This could bring the New York Times back into it. Where are her notes of Blake saying this? Or does she have audio of Blake saying this? Guess who needs that? The Wayfarer team. If Blake said that, they need this evidence. And who's holding it? The New York Times. And what do we call this? We call this new evidence that wasn't available before. What could that do? It could be a basis for this motion to reconsider. It could completely open up these things that the judge mistakenly, and yes, I stand by that, granted these motions to dismiss based on. So this could be huge. And as I said, it goes a long way into showing defamation because what's the basis of proving defamation? Actual malice. If you've got this woman saying that she was never going to file this sexual harassment complaint, but she did so because she thought he was smearing her, voila, actual malice. Or at least it should be back in consideration. So, tomorrow, the 23rd, he could file this document. I will be refreshing my screen deep into the night, Monday night, in the hopes that this document will arrive and make Judge Lyman have to reconsider his granting of these motions to dismiss. Hope hard with me, okay, guys? I hope I've covered all the information that you asked me about for these depositions. If I missed any questions, please let me know in comments and I will try to cover it at some point later. This is a very hopeful Cassidy O'Connell saying stay well and stay tuned and bring on the motion to reconsider.